The United States legal framework operates under a constant, calculated tension. It is built as an architecture of 51 separate but overlapping sovereignties, the 50 individual states plus the federal system. For these parallel systems to function without grinding each other to a halt, there have to be strict rules governing which laws override others. The first division separates actual law from legal commentary. Primary sources of law, like statutes and judicial decisions, create binding rules and obligations. Secondary sources, like scholarly law review articles or legal treatises, analyze the law. They are persuasive to a judge, but possess zero binding authority. Within any single sovereignty, these primary sources adhere to a strict internal hierarchy. At the absolute apex is the Constitution. It dictates the boundaries for everything below it. Below the Constitution sit statutory laws enacted by legislatures, which in turn supersede the administrative regulations written by executive agencies. And sitting at the base is standard case law, judge-made precedent, which is overridden by any valid statute or regulation placed above it. When we zoom out and look at the intersection between state and federal systems, the Supremacy Clause of the U.S. Constitution provides a clear tiebreaker. If a valid federal law directly conflicts with a state law, the federal law always wins out. But the federal government does not govern everything. State courts are courts of general jurisdiction, meaning they hold the authority to hear almost any type of claim by default. Because of this, state judicial systems handle the vast majority of all legal business in the country. Mapping this exact hierarchy of authority allows legal professionals to untangle the inevitable collisions between these 51 sovereignties, figuring out precisely which rule applies when a dispute breaks out. Unlike state systems, federal courts do not hold a blank check of authority. Article 3 establishes the federal judiciary as courts of strictly limited jurisdiction. They can only hear specific types of disputes granted to them by constitutional text or federal statute. This diagram maps out the boundaries of judicial power. Cases rarely fit perfectly into a single, isolated box, and the lines of authority often overlap. The outer edges represent exclusivity. Exclusive federal jurisdiction occurs when Congress drafts a statute specifying that only a federal court can hear the matter. If you are filing for bankruptcy or enforcing a patent, you have no choice. You must go to federal court. On the other side is exclusive state jurisdiction. This covers matters where there is absolutely no federal law involved and no constitutional basis for a federal judge to intervene. The center zone is concurrent jurisdiction. Here, both systems possess the authority to hear the case. The plaintiff gets to choose where to file the initial lawsuit, but if they choose a state court, the defendant may invoke a procedural tool called removal to drag the case into federal court. Jurisdiction dictates the entire playing field of a dispute. If a lawyer files a case in a court that lacks jurisdiction, any ruling that court issues is instantly void. Securing the correct jurisdictional footing is the required first step of any litigation strategy. Once a case securely lands in the federal system, its path is governed by an internal architecture that Congress organized along two distinct axes, hierarchy and geography. This map shows 12 regional circuits. Within these borders operate 94 U.S. district courts, trial-level courts where facts are gathered and verdicts handed down. Directly above them sit 12 courts of appeals, hearing challenges from district courts within their borders. Finally, positioned at the absolute apex is the U.S. Supreme Court. As the court of last resort, it possesses nationwide jurisdiction to review appellate decisions. This geographic and hierarchical map dictates which court's rulings hold power over specific citizens, establishing the functional boundaries for the rules of precedent. Cases must clear two thresholds: subject matter jurisdiction and justiciability. Subject matter jurisdiction requires the U.S. government be a party, the claim involve federal law, or use diversity jurisdiction. Diversity requires parties be from different states, and claims strictly exceed $75,000. If the subject matter fits, the court then examines justiciability. Article 3 restricts federal courts to hearing actual cases or controversies. A judge cannot issue a hypothetical ruling, and they cannot give advisory opinions to the president or Congress. For a case to be justiciable, it has to pass 3 rapid-fire tests. First is standing. The plaintiff bringing the lawsuit must have suffered a genuine, particularized injury. You cannot sue over a law just because you dislike it. Second is ripeness. The claim must deal with an imminent, mature harm. A court will not intervene in an issue too early, strictly prohibiting judicial review of a law while it is still pending in the legislature. Third is mootness. The situation must be a current controversy. If the parties settle or the underlying issue resolves itself, the court will dismiss it. Finally, courts abide by the political question doctrine. Judges will refuse to intervene in matters that the Constitution leaves solely to the executive or legislative branches, like disputes over military affairs. These limits are absolute. If any single element of jurisdiction or justiciability is lacking, the court is legally blind to the facts of the dispute and must immediately dismiss the case. When a court does have jurisdiction and issues a ruling, that decision feeds into the engine of the common law, stare decisis. The phrase translates to let it stand. Following earlier decisions prevents arbitrary bias in the courtroom, promotes judicial economy so courts don't have to constantly reinvent the wheel, and allows citizens and businesses to accurately predict their legal exposure. However, there is a strict limit to this power. Precedent only applies when the legal issues and the material facts of a new case match the ones decided in the old case. And when looking at those past decisions, a lawyer must dissect the anatomy of the judge's written opinion. Not every word printed on the page becomes binding law. The binding precedental effect is limited exclusively to the holding and the rationale. This is the court's official answer to the specific legal question presented, along with the reasoning required to reach that conclusion. Everything else is dictum, stray observations, hypotheticals, or comments that go beyond the facts at hand. While a well-reasoned piece of dictum might be highly persuasive to a future judge, it has absolutely no mandatory legal authority. In litigation, a primary tactical job for any attorney is slicing away the non-binding dictum to isolate the holding, identifying the exact rules that a future judge is forced to obey. This table illustrates the complex calculus of precedent. Whether an established legal authority is mandatory or just merely persuasive depends entirely on the issuing court's relationship to the current court. The vertical rule is simple. Higher-level courts mandate the decisions of lower-level courts within their direct chain of command. A district court must follow the precedent of the appellate circuit directly above it. The horizontal rule governs geography. Courts sitting at the same level, or appellate courts located in entirely different circuits, offer only persuasive authority. A judge in the Ninth Circuit can read a ruling from the Second Circuit and choose to ignore it entirely. When federal and state systems interact, the rules require precision. The state Supreme Court serves as the ultimate binding arbiter of its own state's constitution and statutes. If a federal judge is forced to evaluate a state law claim under diversity jurisdiction, that federal judge must essentially stand in the shoes of the state's Supreme Court and follow its established precedent. Going the other direction, state courts are only bound by the U.S. Supreme Court on matters of federal law. Rulings made by lower federal circuit courts are merely persuasive to state judges. But the ultimate caveat of the U.S. system is that stare decisis is a strong tendency, not an infallible absolute. The Supreme Court maintains the capacity to overrule its own prior decisions. The Dobbs decision overturning Roe v. Wade serves as a stark modern example of the systemic shock when the apex court upends established precedent. The U.S. legal framework operates as a living matrix. A judicial ruling's power relies entirely on its specific coordinates within that structure. If you know exactly where a court sits on the geographic and hierarchical map, you know exactly how much power its words wield.